legislate the law. Exclusive power. Sir, excuse me, sir.
Sorry.
That is to say, land comes under list 2, under entry 18 of the state lists. Lands and buildings vested in or in the possession of the state comes under entry 35 of the list 2 of the state list. In the proposed Waqf bill, the Parliament has no power to legislate any law in respect of the land and building vested in possession of the state in respect of the Waqf property, because the state is only having power to legislate such law. Therefore, the Parliament is now encroaching upon the power of the state legislation in deciding the question of the land and building of the Waqf. Thus, it is completely unconstitutional and divorce the Article 246, Sub-Article 3 of the Constitution of India. This is also hits the basic structure of the Constitution. By exercising any power under List 1 or List 3, state legislative power under List 2 cannot be encroached. There is a difference between a Waqf recognized by the Muslim law and religious endowment and the recognized by Hindu law on the one hand and public charitable trust as contemplated by the English law on the other. The question has been considered by the Privy Council in Vidya Bharuti Tirtha versus Bulsami Ayar, long before. Mr. Amir Ali, who delivered the judgment of the board, observed that it is to be remembered that a trust in the sense in which the expression is used in English law, when the gift is directly to an idol or a temple, the season to complete the gift is necessarily effected by human agency. Called by whatever name, he is only the manager or custodian of the idol or the institution. In no case is the property conveyed to or vested in him. Similarly, that is a basic difference. The Honorable Minister, he was speaking about the Hindu trust. The Muslim law relating to trust differs fundamentally from the English law. Hindu trust follows English law. Muslim law doesn't follow English law. That is a basic difference. Mr. Amir Ali said the Mohammedan law owes its origin to a rule laid down by the Prophet of Islam and means the tying up of a property in the ownership of God the Almighty and the devotion of the profits for the benefit of the human beings. As a result of the creation of a Waqf, the rights of the Waqf is extinguished and the ownership is transferred to the Almighty. It is religious. If it is religious, comes within the ambit and scope of Article 26 of the Constitution. The manager of the Waqf is the Mutawalli, the governor, superintendent, curator. But in that capacity, he has no right in the property belonging to the Waqf. The property is not vested in him and he is not a trustee in the legal sense. Therefore, there is no doubt that the Waqf to which the Act applies is essentially features different from the trust as is known to English law. In Sarabanu versus Union of India, 2017, volume 9, SCC, page 1, the Constitution bench held that any legal provision should be made with the application of known principles of law. If any decision is taken without supporting principles of rule of law, it becomes unpredictable and such a decision is antithesis of a decision taken in accordance with the rule of law. This proposed bill is just contrary to the well-settled principles of law which is established in the country by the judgments have been pronounced not only by the Privy Council, by the Supreme Court of India also. Madam, the various provisions of the Waqf Amendment Bill 2024 is manifestly arbitrary and therefore cannot be passed by the Parliament itself. The Waqf system in Islamic tradition stands as a testament to the enduring values of charity, community, welfare, spiritual dedication rooted in the principles of Sadaqat Jariyah. Waqf in India Waqf properties form the backbone of the Muslim communities, social, cultural, and religious life, playing a pivotal role in maintaining their collective identity. These endowments sustains mosques, madrasas, and cemeteries while providing essential resources to marginalized section of society, especially in an environment where minority communities often struggle for equitable access to public purposes. This is not there. Equality, equitable access is not there in case of the Muslim. That is the reason we are opposing. Over the years, excessive government oversight has raised concerns about the erosion of the autonomy and sanctity of Waqf, which under Islamic law is intended to function independently to serve its religious and charitable purposes. At the heart of the Waqf system administration lies the State Waqf Board, while act as custodian of Waqf properties, ensuring their proper management and alignment with the purposes by Islamic law. These boards have consistently worked to protect Waqf properties from the mismanagement. Madam, the Waqf was centrally first introduced in 1953. Mr. Riju, the Honorable Minister has said, thereafter so many acts, then 1995 Act has come, Amendment 2013, now it is coming. Now by introducing Clause 2, the title of the Act has been amended, Unified Waqf Management, Empowerment, Efficiency and Development. There is no rational basis to make such amendment of the title of the Act. Every Act is intended to make the Act more efficient and development purposes. As for example, the Companies Act was enacted in 1956, thereafter re-enacted in 2013. The Act was brought to regulate the management, empowerment, efficiency and development of the control of the companies. The Waqf Act 1995 had various provisions for management, empowerment, efficiency and development. Therefore, the said proposed amendment to the title is wholly unwarranted. The title, which is being used nearly for 75 years, has no necessity to be amended unless the government wants to have the satisfaction that something new has been done. The proposed amendment to the Waqf Act, which includes a tacit attempt to alter or dilute the historical and religious significance of the term Waqf, is deeply concerning and warrants strong objection. The term Waqf is not merely legal or administrative level. It is a sacred concept deeply rooted in Islamic tradition and jurisprudence. Why you are taking away this? Madam,
they want to interfere in.
please, Sogada, please. The historical development of Waqf legislation in India from the Bengal Waqf Act 1934, Uttar Pradesh Muslim Waqf Act 1960, the Waqf Act 1954, and the subsequent unification under the Waqf Act of 1995 has always retained the sanctity of the term. These laws, while designed to provide statutory governance, have consistently respected the essence of Waqf as a concept grounded in Islamic law. Madam, insertion of Clause 2A. Insertion of Clause 2A tantamount to nullify all earlier judgments, degree and orders of any court in respect of the Waqf and the trust. This attempt is basically taking away the rights of the Muslim, which they have accrued. Any attempt to nullify the Supreme Court judgment by legislative process is illegal and unconstitutional. Clause 3 Roman 9 of the proposed bill that said various sects and subsects have been created. This attempt to create subsect without having any rational object is not a good sign for any religion, caste or creed. If the constitutional provisions empowers the parliament to create caste, subcaste or subclause, only then the parliament can do so. Like the scheduled caste created inside Hindus, but the constitutional provision does not empower the parliament under the guise of the Waqf Amendment Bill 2024, create Aga Khani Waqf, Bora Waqf, etc. The intention to legislate such kind of classification of Waqf board based on subsects the ruling party in the government is having evil intention. If the title speaks about unification, if the title speaks about unification, creation of various Waqf board on the basis of subsect itself creates a de-unification between the sects and subsects of the Muslims. Madam, Clause 3FA of the said proposed bill defines government organization including municipalities and panchayat and autonomous bodies of the state and central government to a Part 9A of the Constitution. Under the scheme of Part 9A, the municipalities and the panchayats are self-government and autonomous bodies. How the properties of the self-government bodies can be treated as a government properties, madam? In a constitutional provision it has made it. By now, by this law, panchayat and municipality has been described as a government properties. It is not a government properties, local self-government bodies. Therefore, there is a distinction. Therefore, this provision is bad. Madam, introduction of definition of the government property seems to be mischievous. Why Waqf will be allowed to define government property? This is an attempt to legalize illegal occupation or Waqf property by government organizations. There are another sin is there. In our JPC, we have said repeatedly, give us the data what the government has occupied the property. Nothing is there. And in Rajasthan, it is a case, is extreme cases. 80% of the property of the Rajasthan, Waqf property has been occupied by the Rajasthan government itself. Practicing Islam for at least 5 years is a precondition for making Waqf is thoroughly unreasonable, irrational and manifest arbitrary. Under the scheme of the Constitution of India, no person can be compelled to practice his own religion. If no person can be compelled to practice his own religion, then such persons cannot be debarred either to offer his property to God or whether he is Hindu or Muslim or any other religion. Practicing religion means day-to-day performance of his religious duty. In a secular democratic country like us, no one can compel to perform any religious duty. If such a provision cannot be made either in the Constitution or in any other statute, no mandatory provision can be made for practicing Islam for at least 5 years for making Waqf. Even if I discharge my religious duty on my own at any place, I cannot be compelled to speak whether I am performing religious duty or not performing the same. Who is anyone can ask me whether I am performing religious duty or non-religious duty? Is it not a violation of a constitutional right? What the Constitution has given you the power to say, to ask me the question, I am discharging religious duty or not discharging the religious duty? A man can believe in performance of religious duty at any point of time of his life, any point of time, before death even. Performing of a religious duty cannot be the basis belonging to that religion. Even in a Hindu mandir which is governed by an act, like Puri Jagannath temple or Kashi Vishwanath temple, there is no such provision that any person practicing Hindu for at least 5 years and then only can donate anything to the deity. Madam, I can't donate. If I want to donate, it's my choice. How my choice can be controlled? I can donate to Hindu mandir. I donate to everywhere. I donate in Hindu mandir. I donate in Muslim property. I donate in the Christian property. I donate in the Buddhist property. I donate everywhere. I donate Vegas. I donate everywhere. How can you control this act? How can I control? By reason of insertion of this clause, no other person of a religion can make over any property to Waqf. The proposed amendment is thoroughly misconceived, arbitrary, irrational, and therefore violates Article 14 of the Constitution of India. Under Clause 3, Roman 9b, existing Clause 3R1 has been omitted. That means Waqf by user is being taken away. Waqf by user is a long-standing practice of Muslims. In our country, Waqf by user is a very common practice, and decades after decades, rather time immemorial. Waqf by user is a practice. The concept of Waqf by user was recognized in our country in the case of courts of words for the property of Magdam Hassan Baksa versus Illahi, Baksha and others. 1912, SCC online, page 45. Madam, the Honorable Apex Court in the matter of Sayyid Muhammad Salih Labbai, dead by LR and others versus Muhammad Hanifa versus LR and others 1976, 4 SCC 780. In paragraph 34, 36 and paragraph 39, categorically accepted this Waqf by user. The necessary is necessary in case of prayers offered in congregation. A single Muslim can also offer his prayers with or without an imam. But if prayer is in a congregation of a Jannat are offered only behind an imam who leads the prayers. And Islam is an extremely modern and liberal religion. There is no question of any person being denied admission in a mosque for the purpose of offering prayers. And that is why the law is so strict that the moment a person is allowed to offer his prayers in a mosque, the mosque becomes dedicated to the public and therefore it's a Waqf property. Therefore it's a Waqf property. Finally, it is not necessary for the dedication of public mosque. Now, madam, in that judgment it has said, so that when a person erects a building with the object of dedicating it as a mosque and permits people to offer prayers therein without declaring that he has constituted it into a mosque and prayers are offered, there bil jammat, the mosque becomes irrevocably dedicated. It is dedicated. Madam, I just give one instance. In the Raishina village, where the residence of the President of India is there. It was a long back, it's a big village. In the big village, there are so many Muslims are there. One Hindu dedicated his property for offer their namaz. And that is the property, that is the mosque is in front of the parliament. In the front of the parliament. Who has not come here? All. Abdul Kalam Azad. So all important political leaders, including Bhutto. And the imam of that is sitting here as one of our colleague, member of parliament. If prayers are offered once in a mosque, it is sufficient to constitute a good dedication. Dedication has been clearly said. Paragraph 39 of the judgment, that the founder must declare his intention to dedicate a property for the purpose of mosque. No particular form of declaration is necessary. The declaration can be presumed from the conduct of the founder, either express or implied. If this is the principle of law, is long-standing in our country, how can you say today you have to register Waqf by user? You have to give a declaration. I don't need to. Therefore, you are trying to buy this bill. You are trying to take away the basic reason of all the judgments of the Supreme Court. This is not correct and this is bad. Madam, neither a document nor express words are essential for dedication of religious or public purpose in our country. Such dedication may be implied for user permitted for public and religious purposes for sufficient length of time. The conduct of those properties is presumed to be dedicated to for religious. It has been said by Sri B.K. Mukherjee on Hindu law. Sri B.K. Mukherjee on Hindu law of religious and charitable. I do not think that anyone in India is here now. Today, in India, there is anyone who understands Hindu law better than the B.K. Mukherjee. No one. He has said so in his book. Anyway, new concepts, smart mans have come, like a smartphone, therefore everything is being done. In the case of M. Siddiqui, through Elas versus Mahanath Suresh Das, 2021 SCC page 1, it has expressly said Waqf by user. Our jurisprudence recognizes the principles of Waqf by user, even absent an express deed of dedication. This is being taken away. Now, long judgment I will not read. This is being taken away by this. Therefore, it hits the basic things. Clause 3, subclause 5 of the said proposed bill. The verbal declaration of Waqf has been taken away. This is contrary to the history of creating Waqf by any individual. Several properties are dedicated as Waqf by a good number of persons to be made as Waqf property. Madam, the deletion of the word either verbally or violates the right of the Muslim as protected under Article 25 and 26 of the Constitution. Therefore, it hits the basic structure of the Constitution. In Commissioner of Police versus Acharya Jagadish and the Abbuddhota 2004-12 SCC 770, it comes from our state. When CPM was in a power, they killed Ananda Margis. In that case, this judgment has come. The protection guaranteed under Article 25 and 26 of the Constitution is not confined to matters of doctrine of belief, but extends to act done in purpose of religion, and therefore contains a guarantee for rituals, observances, ceremonies, and mode of worship which are essential or integral part of religion. What is Waqf then? It's an integral part of the religion. Madam, essential part of religion means the core beliefs upon which a religion is founded. Core belief of the Muslim is that Allah is there. I am dedicated my property to the Allah. Therefore, it's a Waqf property. It is upon the consensus essential power practice that the superstructure of religion is built, without which religion will be no religion. Madam, nobody can say that essential part or practice of one's religion has changed from a particular date or by an event. The proposed amendment clause 3 proceeds with the assumption that Waqf are riddled with the issues of mismanagement. It appears that primary basis of the assumption, very important, the very primary basis of the assumption is the quantum of pending litigation surrounding Waqf. If the basis of identifying body as mismanaged in the amount of litigation that is pending against in this cannot be a rational basis of determining the standard of management of a body. In fact, the Honorable High Court of Delhi in the case of Union of India, Kiran Manua, he has given the details of the pending cases. If pending cases are the ground for bringing the legislation, now I tell you the figure, statistics. In the pending civil cases in Supreme Court, 64,687. Pending criminal cases in Supreme Court, 18,235. Total pending cases, 82,922. And in Waqf, all over India, 14 to 15,000 cases are pending. If it cannot be said to be a basis. Madam, Section 3A, the clause creation of clause 4, Section 3B, insertion of section that mandates that every Waqf prior to the commencement of the shall file the details of the Waqf property dedicated to Waqf. I have already dealt with that. Madam, the Waqf board under its main statute has declared a property to be Waqf in the case that the government has to challenge the same before the appropriate court of law. Oh, sorry. Madam, this is a very important, sorry I have missed it. Now the property, government property, according to minister, the state government officer above the district magistrate will decide the issue. How it can be? How the state can be judge of its own cause? State will decide, this is my property and it will be binding. And the problem is this, the moment it will be claimed, it will not be treated as a Waqf property. Madam, title of the land only can be decided by the civil court, not by anybody. And this title, this land, the power which has been given to decide the land, whether it's the government land or not, that is covered by the state list under entry 18 and entry 35. That is the list 2 of the 7th schedule. Parliament has no power to legislate law in respect of that. If the Waqf board under its main statute has declared a property to be Waqf, in this case the government has to challenge the same before the appropriate court of law. By amending this law, this cannot be done. A person cannot be judge of his own cause. It has to be gone to the civil court. It is well-known principles. Everyone knows about it, that it is with a dispute on the civil law and is there. Who will decide?